long does my will have to be in Minnesota? My name is Andrew Ayers. I'm an estate planning attorney with an office in Edina. And today we're going to talk a little bit about how long does your will really need to be. Now you should keep in mind first that the law only requires three things for a will. It has to be in writing, it has to be signed by the person making the will, and it has to be witnessed and signed by at least two other people. Now you'll notice there's nothing in there about how long the will has to be, how many pages, how many terms it has to be, who has to be written up in the will. So you can have a very short will, you can have a very long will. So the question a lot of my clients will ask are, why are wills so long? So the first thing we have to look at is that each will is different. I've seen wills that are only 2 pages long. My longest will has been about 85 pages. But the key is that each individual will is different. It's unique to you, which is why just going to a website and downloading a form doesn't make sense. If you have children, we want to make sure we have the right provisions for your children. It'll make it a little bit longer, but if they're under 18, we have to have a guardianship provision, and we want to have a trustee as well to manage their money. We can set up a trust within your will, which is something that people don't always know about. It's called a testamentary trust. You want to give specific gifts to specific people. You want to leave money to certain charities. You want to leave your classic car to your brother. These kinds of things need to be in the will, and they can make it a little bit longer. And if you're in a state like Minnesota where we have something called informal probate, well, you want to make sure you have that provision in your will as well so that your estate can be run through the informal probate system and not the formal one. So depending on what state you're in, this can be a huge time saver. If you're in New York, another state where I practice, surrogate's court does not have an informal probate procedure. The probates there can take a long time, there's a lot of fees, and there can be a lot of headaches involved. So when it comes to your will, you can choose how long or short you want to make it. What I found is that some single folks who would think they want a really basic, straightforward will end up with really long, complicated wills because they have family members and others who we need to make sure are correctly identified. And then I have business owners who deal with complex business transactions on a daily basis who say, you know what, just give me the simplest will you have. I deal with all this complexity at work. I just want something basic. So whichever you want to do, your estate planning attorney can help you get the right form for you. I do have to say that do-it-yourself wills are not a good idea. You go online and look for a short will, but you don't know what you're leaving out. Why is that will so short? Is there a provision they left out? If you're in Minnesota and you download a will from a different state, maybe it doesn't have the informal probate option in it. Other people go looking for the longest will they can find online, thinking that the longer the better, it's got everything in it, which it may, but you may not need everything. You may end up with a lot more than you need, and one of those things may end up getting in the way of what you're trying to accomplish. So instead of doing it that way, let's work with the professionals in your life. Talk to your financial advisor, talk to your accountant, work with an attorney to create an estate plan, create a will that is designed for you and your family. If you're ready to get started, you can go to andrewmayers.com. There's a red legal strategy session button on the homepage. Click that and you'll be taken to my personal calendar. We could set up a 15 or 20 minute phone call to discuss where you are in the planning process and give you some next steps to get started.